Thank you very much for giving me an opportunity to talk about the reforms in the criminal justice system so as to reduce the incarceration in the jails of different prisoners. Uh, it's an admitted position that in our jails there's overcrowding of the prisoners. Under-trial prisoners are about 65% occupancy in jail, and the UTPs are either of minor offences or offences falling in the prohibitory clause of Section 497 CRPC, more than 7 years imprisonment, or maybe of life imprisonment. As our distinguished participant was mentioning, that it's correct that in our jails, many of the under-trial prisoners are charged of narcotics, possessing narcotics of different volumes. We have also prisoners in the jail who are facing charges of offences against property. These overcrowding in the prisons can be reduced by adopting certain measures. Number one, we should encourage a system in which the trial should be concluded expeditiously. And for that, we should employ the modern techniques of digitization. The modern IT equipment should be applied to ascertain the minimum benchmark which is required for the disposal of the cases. Number two, we should sensitize our judges that liberty of an individual is very precious, and our bail granting parameters, which are fluctuating from case to case basis, should be applied according to the given situation. There are instances in which the offences, the police unfortunately involve certain prisoners, certain citizens of our society, owing to some feuds or owing to some animosity. In that situation, we can understand the judge should have an eye to understand that the possibility of false implication could not be ruled out. And the moment he grabs the situation, he should not be hesitant to grant bails. And as a matter of fact, I personally think that the right of bail should be acknowledged with great applicability, because bail is just a change of custody of a prisoner from jail to an individual, which we call a surety, with the condition that person will be produced. It's the responsibility of the surety to produce a person when the trial so demands. So in my humble view, my experience working on the criminal side is that the most of the cases pouring into our judicial system are for the grant of bails. As Madam Nasser has pointed out, very rightly so, that in our jail we have seen so many prisoners who should not have been sent to the jail at the first instance. Their cases are false, they are politically motivated, they are based on vengeance, animosity, or feud, and sometimes the offences are of such a nature that the police is in habit of involving it just to show their efficiency. So in these like situation, I think the law of bail is very much available to a judge, which he should exercise whenever so demanded. Well, answer to your question is this: my paper is already there, but I will not be able time to see that. But perhaps answer to any question, I will dial it upon. Thank you.